Good morning, stakeholders, and welcome to your sensitization session with the Office of Procurement Regulation. I am Tamara Roy, Head Corporate Communications, and we're extremely pleased that you're able to join us today. I will be your moderator for this session. We will get straight into today's program by inviting our Chairman and Procurement Regulator, Ms. Beverly Khan, to formally open the session with a few remarks. Ms. Khan?
Thank you, Tamara, and good morning to PS Suite, PS Ganga Prasad, and DPS Roberts. It is my pleasure to be part of this session. It's my first sensitization session since assuming this role, and I want to take the opportunity to especially thank the OPM for the opportunity to continue to engage on the important matters before us related to the new procurement regime with the full proclamation of the Act on April 26. This morning, the team here has prepared a presentation to be made. We are not sure specifically what are the issues and what are the areas you would want us to focus on, but by all means, we can engage so that we can provide you with the feedback that you require. We understand that many of the public bodies, and in particular, our ministries, have been having some challenges, and we are here to assist you in overcoming those challenges, which is critical for us in terms of the full utilization of the new procurement regime. It's very important that as we go forward, that all our public bodies do the readiness assessment. We had done one on the OPM some time ago, and we had identified some areas that we needed to strengthen, but we have not received the latest version of that readiness assessment. So I would urge PS Suite that if we can at least get that, that was issued in May of this year, and it will be very important, in terms of the partnership that we want to build with the OPM, that we are able to provide that support and guidance to you. In addition, we have, we really need to understand, as I said, the OPM challenges, and that readiness assessment will help us in that regard. So I don't want to necessarily delay the session, which is what we're here for. So I would pass on. So thank you very much, PS Suite, PS Ganga Prasad, and DPS Roberts. And I would pass you on to Ms. De La Rosa, who would give an overview of the Act itself. Thank you.
Thank you very much, Chairman. And good morning to all attendees from the Office of the Prime Minister. So before we start today's proceedings, I would just like to inform that the Office has set up facilities to address any queries or questions that you may have. And you can do or submit your questions or queries via the two emails on the slide. So first we have stacia.mahabir@opr.org.tt or feedback@opr.org.tt. And for today's session, we will delve into an overview of the Public Procurement and Disposal of Public Property Act as amended. We would also go into an overview of the Public Procurement and Disposal of Public Property Regulations, and then we would deal with compliance with the Act, regulations, and handbooks and guidelines dealing with the readiness assessment checklist. So the Public Procurement and Disposal of Public Property Act is an act to provide for public procurement and retention and disposal of public property in accordance with good governance, namely accountability, transparency, integrity, and value for money. Of note, the Act also established the Office of Procurement Regulation, as well as repealed the Central Tenders Board Act and related matters thereto. So when we speak of the objectives of the Act, there are 11 principles or objectives that are identified in Section 5 of the legislation. And these are accountability, integrity, transparency, value for money, efficiency, fairness, equity, public confidence, local industry development, sustainable procurement, and sustainable development. And we will delve briefly into the definitions of each principle or objective. So accountability essentially means that it allows interested parties to ensure that the objectives are being achieved, and that is, you are to be accountable for your actions and decisions taken as it pertains to the public procurement and disposal proceedings. Integrity speaks to avoiding corruption as well as conflicts of interest. Transparency speaks to ensuring that appropriate information is placed in the public domain. Value for money, achieving efficiency, economies of scale, as well as cost competitiveness. Efficiency, you want to ensure that you achieve procurement objectives within reasonable time and at a reasonable cost. When you deal with fairness, you speak to ensuring that all suppliers and contractors are treated equally and they are judged on a level playing field. Equity, all suppliers and contractors must have a fair chance of winning a procurement or disposal contract. Public confidence speaks to trust. So the public must trust that you as a public body are doing what is necessary as it pertains to your public procurement and disposal proceedings. We speak to local industry development. And local industry development includes all activities that serve to enhance local capacity and competitiveness. And this includes the involvement as well as participation of local persons, firms, as well as investment of capital in procurement proceedings, ensuring that if you are engaging international suppliers or even local suppliers, that there is knowledge transfer during the conduct of the program of goods, works, or services that you are procuring. Sustainable procurement, and this is the process whereby you as a public body shall meet your needs for your goods, works, or services in a way that not only achieves value for money, but it ensures that future generations are not impacted. And sustainable procurement also speaks to the minimization of damage to the environment in the way that you conduct your procurement and disposal activities. Sustainable development, and these are developmental projects that meet the needs of the present without compromising the ability of future generations to meet their own needs. So who is the Office of Procurement Regulation? I'm sure all of you know that the Office of Procurement Regulation exists, but we will briefly delve into some of the functions of the OPR. So the OPR, as discussed before, was established by the Public Procurement and Disposal of Public Property Act. We are a regulatory body and we are governed by an independent board. And our board would have been appointed by the President of Trinidad and Tobago, subsequent to consultation with both the Prime Minister and the Leader of the Opposition. The board would have been appointed in January 12, 2018, and it comprises 10 members in accordance with Section 10 of the Act. And of note, the independence of the OPR is made clear in Section 13, subsection 2B of the legislation, which states that the OPR shall not be subject to the direction or control of any other person or authority in the performance of its functions, but we are accountable to Parliament. So we'll go into the Section 13 functions of the Office of Procurement Regulation. And briefly, the functions are, we're responsible for establishing a comprehensive database of information as it pertains to public procurement tenders, awards, and values for contracts. And this is where your reporting becomes very important because your reporting filters into that database. We're also responsible for setting training standards, competence levels, and certification requirements to promote best practice in procurement. And of note, the training standards would have been established in November of 2020. That document is published on the office's website. And we would have also done extensive rollout of those training standards with public bodies as well as human resource professionals. The office is also responsible for issuing and reviewing guidelines in relation to public procurement and the retention and disposal of public property. And so far, the OPR has issued 27 guidelines in relation to public procurement, retention, and disposal. And these guidelines are readily available on our website. We're also responsible for preparing, updating, and issuing model handbooks, also incorporating standardized bidding documents, procedural forms, and other relevant documents. And of note, the office has published 17 handbooks and procedural templates on our website. We're also responsible for approving in respect of each public body special guidelines and handbooks in relation to your procurement and disposal functions, and we'll delve into that a little later. We're also responsible for promoting the use of technology in public procurement. We also provide best practice advice in the conduct of procurement activities. And as of July 5th, 2023, today, we would have conducted 348 sensitization sessions and also responded to approximately 1,667 stakeholder queries. We also have a frequently asked questions segment or section on our website that is readily available that will also assist you in getting information that you need for your procurement and disposal activities. The office is also responsible for auditing and reviewing the system of procurement and disposal of public property to ensure compliance with the objectives of the Act. And of note, audits will be conducted by the OPR's team to provide objective insight to improve efficiency of the operations within your procurement and finance departments, to evaluate risk as well as to protect assets, to assess your organizational controls, and to, of course, ensure compliance with the Act, the regulations, and handbooks and guidelines. Another function is that we're responsible for harmonizing policies, systems, and practices as it relates to procurement and disposal. We're also responsible for reviewing procurement practices and delivery systems on an annual basis to identify best practices, as well as determining and developing system-wide databases and technology. The office is also responsible for promoting the awareness of public bodies as it relates to public procurement and disposal of public property. So we do this promotion of awareness via sensitization sessions, as we are having today with the Office of the Prime Minister. We have also acquired an e-learning authoring tool as well as a learning management system, and the LMS will have been launched on the 20th of June, 2023. So that your named procurement officers will have access to learning material that will be self-paced. And this content that we provided on the LMS deals with the Act, the regulations, handbooks and guidelines, systems, policies, procedures, as well as processes as it relates to public procurement and disposal. The office is also responsible for investigation, and this comes via Section 13, subsection N of the legislation. And the office can investigate on its own initiative or upon complaint from any party involved in public procurement or disposal of public property or any member of the public, any alleged or suspected breach of this Act. And an investigation can be initiated by the office, via the regulator's office, via the office's whistleblowing portal, or as a matter of public interest via complaint. And note that an investigation can happen at any time. Challenge proceedings. So pursuant to Section 49 of the legislation, a supplier contractor can now bring challenge proceedings against a public body where a public body made a decision or took any action that is not in compliance with the legislation, or the supplier contractor feels that they have suffered or is likely to suffer loss or injury because of a decision you would have made in your public procurement or disposal proceedings. So a supplier contractor under the legislation can now apply for a review of a decision or action taken by you during your proceedings, as well as any public body who has been affected by the application has a right to also participate in these challenge proceedings. And challenge proceedings are specific to procurement proceedings and must be made within specific timeframes that are set out in the legislation. And that is either during the standstill period pursuant to Section 35, subsection 2, or when no standstill period has been indicated by your public body, a supplier contractor can apply within 7 days after the publication of your notice or decision to take an action in your procurement proceeding. So now the legislation would have also provided for an ineligibility list. And this list is a list of suppliers or contractors who shall not participate in procurement proceedings. Where supplier contractors added to this ineligibility list, the fact of this addition shall be published and communicated to all public bodies. So all public bodies are aware for a certain period of time, they are not allowed to do business with this particular supplier contractor. So a supplier contractor or senior officer who has engaged in prohibited conduct is placed on the ineligibility list, which has the effect of excluding them from participating in public procurement proceedings. And pursuant to Section 58, subsection 3, the office may add a supplier contractor to this ineligibility list where they consistently fail to provide satisfactory performance, they are found to be indulgent in corrupt or fraudulent practices, or they are convicted of an offense under this Act. And for noting purposes, how to make a report. So a report can be submitted with supporting documents to either the accounting officer or equivalent of a public body or to the OPR via the ineligibility@opr.org.tt email address. And the report must provide at least the following information: the name and details of the intended respondent, the grounds or basis on which the report is seeking to intend respondent to be placed on the eligibility list, and any facts or evidence supporting your grounds for having them placed on the ineligibility list. So let's deal with some amendments to the legislation. The Public Procurement and Disposal of Public Property Act would have been amended 3 times, and of note, Act number 5 of 2016 would have provided for the establishment of the Public Procurement Review Board. And this board provides the opportunity for those affected by decisions of the Office of Procurement Regulation, to have those decisions reviewed by the Procurement Review Board. The Amendment Act number 3 of 2017 provides for reduction in the term of the Office of the Regulator and other members of the board appointed under the Act to govern the office. And Amendment Act number 27 of 2020 provides for 7 amendments, and we'll go into these amendments individually. So these amendments are, firstly, the definition of bid rigging would have been amended. The second feature would be the amendments to Section 7, disposal of public property, due diligence, that is criminal offenses, the time or decision of review of an action by an entity, conduct of influencing public officers, as well as options available to public officers. So the definition of bid rigging would have been changed from collusion between persons for the purpose of manipulating the proceedings to collusive price fixing and anti-competitive behavior, which is designed to unfairly influence the outcome of a competitive tender process in favor of one or more bidders. Section 7 of the legislation would have been amended, and the following words in red would have been deleted. So the section now reads, to the extent that this act conflicts with an obligation of the state under or arising out of the following, a treaty or other form of agreement which TNT is a party with one or more states or entity within a state. An agreement entered into by the government of Trinidad and Tobago with an international financing institution, or an agreement for technical or other cooperation between the government of Trinidad and Tobago as well as the government of a foreign state, the requirements of the treaty or agreement shall apply. So everything in red as it pertains to the procurement of goods, works, or services having to be in compliance with the legislation has now been removed subsequent to the amendments in 2020. Amendment to Section 7, Subsection 3 of the legislation also resulted in the subsection no longer applying to reports related to national security, and that section relates to the Section 29 due diligence requirements. Further to the amendments in 2020, the legislation no longer applies to legal services, debt financing services for the national budget, accounting and auditing services, medical emergency or other scheduled medical services, or such other services as the Minister of Finance may by order determine. And of note, the Minister of Finance is required to submit to the office annual guidelines which outline the circumstances under which these exempt services mentioned above may be procured. Of note, the Act no longer provides for the office to act for, in the name and on behalf of the state, to dispose of real property owned by the government of Trinidad and Tobago. So Section 29, which is the due diligence requirements, has been amended. So formally, the section would have stated that a director have not, and that their directors or officers have not been convicted of any criminal offense. That would have been amended to state that they have not been convicted within the past 10 years of corruption or fraud-related offenses locally or internationally, either as individuals or as directors or officers of a company. And this is important because Section 29 relates to the due diligence requirements for your pre-qualification processes. The time of decision for reviewing actions taken by a procuring entity has also been amended, and this has been amended from 20 working days, so the office now has 30 working days pursuant to Section 50 of the Act. Conduct influencing a public officer. So pursuant to Section 59 of the Act, as public officers involved in public procurement and disposal activities for your public body, you cannot act or make decisions for the purpose of gaining any advantage or concession for yourself or any other person by the way you conduct your procurement or disposal activities. And of note, the legislation now defines relative to mean either a spouse, a cohabitant within the meaning of the Cohabitation Relationship Act, father, mother, brother, sister, son, or daughter. And if you are involved in public procurement or disposal, please take note of what relative is now defined as. So we will delve into the impact of the legislation on public bodies. So who is now responsible for procurement? So pursuant to Section 61, subsection 2, the legislation now requires each public body to have a procurement officer who shall be responsible for public procurement and disposal for that body. That public procurement officer must be notified in writing, that is their name as well as their designation, to the Office of Procurement Regulation. Of note as well, Section 613 goes on to state a reference to the Act to the commission of an offence by a public body shall be construed as a reference to the commission of an offence by the procurement officer referred to in subsection 2. That is the named procurement officer, or an officer who purports to act in such capacity if it is proved that the offence was committed with his direct consent or he with knowledge did not exercise reasonable diligence to prevent the commission of the offense. So not only would the named procurement officer be liable if it is that any decision is made or action taken where someone puts themselves in the position of the named procurement officer, they also attract liability under subsection 1(3). And Regulation 3 of the Procurement Methods and Procedure Regulation states that the named procurement officer shall be suitably qualified, experienced, and competent to prepare the annual procurement plan for the approval of the accounting officer or equivalent in a public body. So pursuant to Section 6 of the legislation, any procurement of goods, works, or services, or retention or disposal of public property that is now not done in accordance with the legislation, or it goes further to state any procurement contract or agreement that is not entered into in accordance with the Act can now be considered void and illegal. Some reporting requirements. So now, pursuant to Section 27, a procuring entity is responsible for no later than 6 weeks after the approval of the national budget for publishing on your website or in any other electronic format information regarding all planned procurement activities for the following 12 months. You're also responsible for updating the information as necessary and provided a printed copy of the information upon request and payment of the prescribed fee by any member of the public. And of note, what you're publishing on your website or any other electronic format is your schedule of planned procurement activities, not your actual annual procurement plan. The APP or the annual procurement plan is what you submit to the office. So the procurement depository, Sections 26 of the legislation requires the office to establish a database to be known as the procurement depository, to which suppliers and contractors can submit information with respect to other things, their qualification and experience. The depository shall be accessible to the public for viewing. Any supplier contractor who submits information to the depository is responsible for ensuring the accuracy of that information submitted. In the conduct of your due diligence pursuant to Section 29, you as a public body, you may require a supplier contractor who has submitted information to the depository to confirm the accuracy of the information submitted. So you do have that opportunity as well. Going into Section 29, in your due diligence requirements for your pre-qualification exercise, you must ensure that suppliers and contractors have the legal capacity to enter into the procurement contract. When we speak to legal capacity, it's not simply that the person, the supplier contractor, has attained the age of 18, they are mentally fit to enter into the contract. We also speak to whether that supplier contractor is registered in accordance with the laws of Trinidad and Tobago, as well as they have paid up to date their taxes and so on. You also have to ensure that the supplier contractor is not insolvent, it's not in receivership, bankrupt, subject to any judicial or court proceedings as well. That they have not, and their directors or officers have not been convicted of any criminal offense convicted within the past 10 years of corruption or fraud-related offenses locally or internationally as individuals or as directors or officers of a company. So now you have C being replaced, what is in red has been deleted, and what is in blue is now what you're required to ensure for a supplier contractor for the due diligence requirements. You also have to ensure that that supplier contractor has fulfilled his obligation, of course, to pay all required taxes and contributions, that they have the necessary professional and technical qualification, competence, financial resources, the necessary equipment and other facilities, physical facilities to perform the procurement contract, as well as they meet relevant industry standards. In requirements established pursuant to Section 29, shall be set out in your pre-qualification or pre-selection document. So this must be explicitly stated in your solicitation documents, your pre-qualification documents for suppliers or contractors. So now section 35, subsection 2 has introduced a standstill period. And the standstill period means a period from the dispatch of a notice as required pursuant to section 35. That is a notice indicating to all persons who would have bid that you intend to award the contract. And during this time, you cannot accept the successful submission. And it allows a supplier contractor to challenge a decision once they are notified via that notice required in section 35, subsection 2. So now you're required to promptly notify each supplier contractor who has presented a submission or bid to you of your decision to accept the successful submission at the end of the standstill period. Of note, however, the legislation also provides that a standstill period shall not apply to the award of contracts where you as a public body determine that urgent public interest consideration requires that you proceed with awarding the contract without a standstill period. The legislation also speaks, of course, to disposal, and disposal is, well, it includes the transfer without value, sale, lease concession, or other alienation of property that is owned by a public body. And public property means real or personal property owned by a public body. Of note again, the amendments in 2020 would have removed disposal of real property from the ambit of the Office of Procurement Regulation. You are also required to develop guidelines as it relates to your disposal and retention activities, and those special guidelines would have to be approved by the office. So some specific impacts of the legislation of public bodies, and we tried to do like a synopsis here so you can see. Section 64 removed the Central Tenders Board. So now all public bodies are required to carry out your disposal and procurement activities. So the legislation would have introduced a decentralized approach to public procurement as well as disposal. Pursuant to section 61(2), you're now required, each public body is now required to have a named procurement officer or a procurement officer who is named to the office. Pursuant to section 55, you're now responsible for establishing a disposal committee to assist in your disposal activity. Pursuant to part 5 of the procurement methods regulations, you're now responsible for establishing a procurement and disposal advisory committee. Pursuant to section 29, you're now responsible for developing your annual procurement plan. Pursuant to section 30, you're now responsible for getting your procurement handbooks and special guidelines approved by the Office of Procurement Regulation. You're now responsible for implementing internal controls for public procurement. And pursuant as well to Regulation 3 of the Records of Public Proceedings regulations, you're now responsible for developing and managing an efficient filing system. So let's delve into some roles and responsibilities of team members, because the requirements under the legislation are numerous. So the accounting officer, the CEO or equivalent, and the financial regulations and the Check and Audit Act speaks to the responsibilities or accountabilities of accounting officers. So section 4 states, an accounting officer shall be responsible for ensuring that the financial business of the state for which he is responsible is properly conducted, and that funds entrusted to his care are properly safeguarded and applied only for the purposes intended by Parliament. Section 5 states, all accounting officers are personally responsible for the due performance of their financial duties of their departments, the proper collection and custody of all public monies received by them, as well as for any accounts rendered by them or under their authority. The Procurement and Disposal Advisory Committee, and we discussed that the procurement methods regulations now require that you establish this committee. And PDAC is appointed by the procurement officer, and they're responsible for reviewing the procurement records, the report and recommendations for contract award, and they determine whether the following 3 criteria have been met. The approved processes as set out in your handbooks and guidelines were followed, that either the approved procurement, retention, and disposal strategy aligned or aligns with your annual procurement plan, and whether value for money has been achieved, and they would advise the accounting officer accordingly. So the composition of PDAC, either your corporate secretary or your head legal, your head of finance, and a subject matter expert. So the named procurement officer, and pursuant to section 61(2), we know that the named procurement officer is now responsible for ensuring that training is provided to the procurement staff in the Code of Conduct, compiling the annual procurement plan for approval by the accounting officer and submission to the Office of Procurement Regulation, compiling the annual procurement performance report within 1 month of the end of each fiscal period, customizing the handbooks and special guidelines that you currently have for approval to the Office of Procurement Regulation, and ensuring that the procurement, retention, disposal of public property functions are planned and executed in a manner designed to achieve the objects of the Act. So the finance manager is responsible for the list of procured items categorized under the main 3 groups, goods, services, or works, to determine expenditure by either groups and categories for the past 3 years, and that is estimated versus actual spend where this is available, and determining anticipated spend for the upcoming fiscal year. Your human resource department is responsible for the development of a code of conduct. Of note, the Office of Procurement Regulation has developed 2 codes of conduct that would be utilized in procurement proceedings, and that's Code of Conduct for public bodies and public officers, and a Code of Conduct for suppliers and contractors. HR is also responsible for finalizing job descriptions for roles under your procurement department, as well as your disposal rules, generating a list of staff that is likely to be involved in your procurement function, and hire externally to supplement the need where required, as well as develop a training plan for your department, ensuring that your procurement practitioners are properly trained and certified. Your Information, Communications, and Technology department, responsible for facilitating the implementation of a secure record management system for procurement and developing a robust security system for access and storage of all your procurement documents. And this is important because if the office requests any documentation from you, you must provide it to the office. So you must ensure that you have the documents readily available and they are properly stored and secured. Your legal department should be actively involved in the review of your solicitation documents, including the draft contract. They should be actively involved in your evaluation process, negotiation and finalization of contracts to ensure that necessary legal information is included. They should participate in any negotiations that you have with your suppliers or contractors. They should review and finalize your code of conduct. You can also wholly adopt the office's general guidelines, the code of conduct that would have been developed. And they are also responsible for sensitizing all staff on the Act in collaboration with your named procurement officer. Well, the Act as well as the regulations. And all internal departments. So each department is responsible for preparing a list of goods, works, or services to be procured with the corresponding cost estimates for the upcoming fiscal year. Departments must forward all procurement requests to the procurement department because your named procurement officer is now responsible And cross-functional teams must be developed to agree on the procurement and disposal strategy. And this process is important because now you're required to develop and submit your annual procurement plan for approval. So now that we have discussed the legislation, that is the Public Procurement and Disposal of Public Property Act, we go into the Public Procurement and Disposal of Public Property regulations. So there's a suite of 10 regulations to operationalize the legislation, and these were approved by the House of Representatives in 2020, January of 2020, and the Senate in February of 2020. And all the regulations are available for download on our website. I will briefly discuss each regulation so you get an idea of what is included in them. So regulation, the participation in procurement regulation deals with domestic preference. And regulation 3 states, a supplier contractor who participates in an international competitive bid may benefit from domestic preference mechanisms set out in your bidding document where the procurement involves, and it lists, for instance, a supply of goods which is manufactured exclusively in Trinidad and Tobago, etc. Regulation 3, sub-regulation 4 goes on to speak to the margin of domestic preference. A supplier contractor who participates in an international competitive bid may benefit from domestic preference mechanisms set out in the bidding document where the procurement involves the performance of works and the supplier contractor proposes employment of at least 65% of domestic labor. The participation of joint ventures and other consortia is indicated in Regulation 5. A supplier contractor may rely on the capacity of a joint venture or consortium to fulfill the legal, financial, and technical requirements of procurement proceedings. The procurement depository is also dealt with in Regulation 6 of the participation in procurement regulation. Pre-qualification and pre-selection regulation. So Regulation 6 deals with the process for clarification of pre-qualification documents. Regulation 10 deals with your invitation for pre-selection. And we know the pre-selection process is where you identify a small or core list of suppliers and contractors who are best able to meet your needs, and these are pulled from your pre-qualification listing. So the regulations also provide for your pre-qualification process. It deals with the assessment for pre-qualification at Regulation 11, as well as pre-selection scoring criteria, taking into consideration, of course, the supplier contractor's relevant experience, the qualification of key members of staff proposed, transfer of knowledge, and the extent of participation in Trinidad and Tobago. Your procurement methods and procedures regulations. At Regulation 3, it deals with strategic procurement, and we would have delved a little into that previously. So it just states that the named procurement officer, of course, shall be suitably qualified and experienced and competent. At Regulation 4, it deals with the establishment of thresholds, and it states the office may, by guidelines, establish different thresholds to be used for different methods of procurement. Sub-regulation 2 states a procuring entity may establish specific threshold values in your special guidelines and handbook that would be submitted to the Office of Procurement Regulation for review. So there are two avenues by which thresholds can now be established, either via the office by guidelines, or you as a public body, you may also establish specific thresholds, but it must be included in your special handbooks and guidelines, and it must be approved by the office. Part 2 deals with open bidding and the process by which you must adopt if you are utilizing the open bidding procurement method. Part 3 deals with limited bidding, that is Regulation 8. Part 4 deals with the request for quotation and how you can utilize that procurement method. Part 5 deals with single source selection, that is Regulation 12, and the circumstances under which you can employ or utilize single source selection in your procurement activities. Part 6 deals with sole source selection and the exceptional circumstances via which you can utilize the sole source procurement method. Part 8 or Regulation 17 deals with framework agreements, and how you are to set up a framework agreement is also provided for in the regulations. Regulation 19 deals with electronic reverse auction. Regulation 21 or Part 9 deals with the Procurement and Disposal Advisory Committee, and we discuss the composition of that committee. Regulation 25 speaks to your technical specifications, how you develop technical specifications in your bidding or pre-qualification documents. Regulation 26 also goes on to indicate where appropriate for your technical specifications. You must include, for instance, a full description of the requirements, any functional description that you may have, any performance parameters, any inspection and testing, etc. So it gets very detailed. For the evaluation regulations, Regulation 3 deals with the establishment of your evaluation criteria. It states that you must include your evaluation criteria and methodology in your bidding document. So this is something that you must publish in your solicitation documents. Regulation 4 deals with price factors, and it states a quantifiable evaluation may include, for instance, the period for completion of the work or service or the delivery of the good, the life cycle operational costs, any needs that you may have for after-sales services or technical assistance, any needs that you may have for spare parts, your payment terms, any extended warranty, etc. Regulation 5 also deals with non-price factors, and non-price factors, as stated in the regulation, includes, but it's not limited to, the quality of the methodology and work plan that is submitted by the supplier contractor, the performance, capacity, or functionality feature of the good, works, or services that you are intending to procure, and any other sustainable feature. The procurement of consultant regulations deals with, at Regulation 8, the submission of proposals and how submission of proposals should take place. It's either combined in a single envelope or in a separate envelope in accordance with approved guidelines that will be issued by the office. Regulation 10 deals with the submission of proposals as well. And the regulations actually outline the evaluation methods that you can utilize for the procurement of consultants. So it goes into quality and cost-based selection, quality-based selection, fixed budgets, least cost selection, as well as consultants' qualifications. The record of proceeding regulations at Regulation 6 deals with the requirements to keep your record. So a procuring entity now as a public body, you must maintain an easily accessible and retrievable record for each procurement proceedings, which shall be marked with a record management reference number. At Regulation 4, it also indicates what shall be contained in your record of procurement proceedings document. So it goes into the complete bidding document, must be in that file, A description of the object of the procurement must also be included in that file. A list of each participating supplier contractor and his or her qualifications. The reason or reasons for limiting participation where you have employed a limited participation procurement methods. Any request for clarification that would have come from suppliers, contractors, and any responses that you would have given. If you have canceled any bids, the reason for the cancellation. The statement of the reason for your choice of procurement method must also be included. The tender price, a decision to suspend the standstill period, etc. For the retention of public property and disposal of personal property regulations, it goes into the risk-based approach to retention of public property, as well as how you dispose to employees. The challenge proceedings regulations deals with that regulation to the procedure for review. Ineligibility regulations deals with the hearing and evidence, as well as the ineligibility sanctions. And the miscellaneous regulations deals with committee members as being set up by the Office of Procurement Regulation. We now go into compliance. I do see that PS Suite has his hands up. PS Suite, if you would like to unmute and you can ask your question.
No, sorry, I took it down. I don't know if it's still showing up, but I took my hand down. Came up by mistake. Go ahead,
Not
please.
a problem. Okay. So we briefly delve into the readiness assessment checklist. So the readiness assessment checklist has a total of 53 steps, and we're not going to go through all 53 steps, but we would have highlighted some of the main steps that you would need to be aware of. So at column A, it deals with codes of conduct. And as indicated, the Office of Procurement Regulation would have drafted and published 2 codes of conduct. One, the Ethical Code of Conduct for Public Bodies and Public Officers, and the Ethical Code of Conduct for Suppliers and Contractors. So you can wholly adopt the Code of Conduct that we have issued via general guidelines. You are required to implement these codes of conduct in both your procurement and disposal proceedings, and train staff and stakeholders on the code of conduct. For the internal control framework, and this framework assists in identifying any risk and the associated controls to mitigate those identified risks in your procurement and disposal functions. So you're responsible for developing an internal control framework, as well as establishing a delegation of authority for the conduct and management of your procurement and disposal activities. At column C, it addresses the capacity needs assessment, and this assessment assists in identifying where your current staff possesses or whether they possess the required competence to execute your procurement and disposal functions in compliance with the legislative framework. So you must also assess the capacity needs of your public body, taking into consideration the mandate and level of expenditure, as well as establish an organizational structure for both procurement and disposal, as well as the relevant job descriptions. At column D, the RSC deals with recruitment. And of course, pursuant to section 61(2), you're now responsible for having, or you're required to have, your named procurement officer. So you must either recruit, if necessary, or appoint from your current staff. You must notify the office in writing of the name and designation of your procurement officer. Pursuant to Regulation 5 of the Retention and Disposal of Personal Property Regulations, you're now also responsible for assigning a public officer for retention of stores and equipment. And pursuant to Regulation 5 of the Retention and Disposal of Personal Property Regulations, you're now responsible for assigning a trained, technically capable public officer for stores and inventory. For records management, as well as the procurement depository, you're now responsible for establishing a records management system. As well as pursuant to the regulations, you're required to establish a stores and inventory management system. To gain access to the procurement depository, You must, of course, inform the OPR of the name, designation, and contact of not only your named procurement officer, but your accounting officer, and this will be done via new user requests. And you're responsible for creating lines of business on the depository utilizing UNSPS codes. For handbooks and guidelines, pursuant to Section 30, you have the following options. You can either adopt the office's handbooks and guidelines, or develop special guidelines in relation to your public procurement and disposal proceedings. If you are choosing to adopt the office's handbooks and guidelines, you must inform us in writing. Or if you have decided that you will draft or develop your special handbooks and guidelines, you must ensure that those are submitted to the office and you obtain the approval of the Office of Procurement Regulation. For PDAC and the Disposal Committee, pursuant to Regulation 21 of the Procurement Methods and Procedures Regulation, you must establish your Procurement and Disposal Advisory Committee. So you must appoint members as well as alternate members. And pursuant to Section 55, you must also establish a Disposal Committee. So to ensure that your public body, as the procuring entity, as well as the individuals involved in public procurement, are skilled and capable, you're also responsible for providing internal training for staff on the Act, regulations, handbooks and guidelines, and special handbooks and guidelines that are approved. You're consistently required to assess the capacity of all staff, not just the named procurement officer, but all staff that's involved in the procurement and disposal proceedings. And in assessing this capacity, you're required to utilize the office's competence standards that would have been developed and published in 2020. And you're required to provide training opportunities to your procurement and disposal staff. For the annual procurement plan, so you're now required to prepare the annual procurement plan and schedule of planned procurement activities and obtain the approval of your accounting officer. You must submit the annual procurement plan to the OPR within 6 weeks of the approval of the national budget. And pursuant to Section 27, you're required to publish the annual schedule of planned procurement activities on your website or in another electronic format. Your reporting requirements, responsibilities under the legislation are now, so Section 36 requires public bodies to publish on its website or other electronic format notices of award of procurement contracts or framework agreements. Section 37 requires you as a public body to submit quarterly reports to the OPR, and this must be done within 3 weeks after the end of each quarter. You are now responsible for preparing and submitting the annual procurement performance report within 6 weeks after the end of each fiscal. And once required or requested from the office, you must prepare and submit any other documents or reports. And finally, for compliance monitoring, to ensure that you consistently monitor your procurement and disposal functions and to ensure compliance with the legislative framework, you're required to prepare and submit the annual procurement performance reports within 6 weeks of the end of the fiscal year, continuously monitor the procurement and disposal functions, and implement measures to improve the performance and address any gaps and weaknesses identified in your procurement and disposal functions. And that would bring me to a close of the presentation for today's proceedings.